the patent laws in Australia are about to change for the first time in, let's say, 23 years, of this level of significance. What's this all about?
Okay, what this is all about is, and it's called raising the bar, and the idea is to make it harder to get a patent in Australia. The other side of that coin is that it means that if you do get a patent in Australia, you've got a greater chance of it being valid and usable to protect your innovation against competitors.
So how are they tackling this?
There's two main areas that are changing in the legislation. One is in the assessment of inventiveness. You are going to have something that is more inventive now to get a patent than what you had previously. And the way they're doing that is they're changing some of the criteria against which you have to prove that you've got an invention.
Because up until now, there wasn't any, or there wasn't as stringent testing of inventiveness.
That's right. So, well, I mean, the fundamental questions are still the same. You've still got to have something that's literally new and something that's not an obvious solution to the problem. But it's in the assessment of what's obvious versus what prior information is changing. So it used to be a very limited set of prior information that could be used to compare with your invention, and now that's been expanded quite a lot. So there's a lot more different things that either the Patent Office or someone else who wants to challenge your patent can bring in and line up against your claims.
So early on it was restricted to the Australian market or the local market, and now it's global.
Yes, so novelty in terms of whether you're new or not was previously and still is about everything that's been published in the rest of the world. But the key change here is that when assessing is your invention an obvious solution to the problem, you only used to be able to have to deal with things that were brought up, the level of common general knowledge and the level of information that a typical Australian competitor would have looked at. Now you actually have to be compared with the level of knowledge and information that any global competitor would have looked at, and that is quite a bigger pool of information.
I recall something about it being useful. The invention needs to be proven to be useful to get a patent. Is that new?
What's changed there is that you always had to have something useful to get a patent. Previously it wasn't examined at the Patent Office, but now the Patent Office is allowed to raise objections that what you're claiming as your invention may not be useful. That's probably not going to be a major concern for a lot of people, but in some particular areas, perhaps in the areas of computer algorithms and computer-related inventions, for example, that may also come up as an issue.
Okay. Come the 15th of April 2013, it does change.
Yep.
Is there things applicants need to be aware of around that date?
Yes. So the key thing to realise with that is that if you request examination of a currently pending application before that date, your application and your patent will only have to meet the previous lower standard. But if you request examination or if you file your application after that date, you will have to meet the higher standard. So there's an advantage in getting in quick and filing your application or doing your request for examination earlier so that you still get the lower standard.
There are some changes to managing the application process too, aren't there, in how your patent attorney should be programming it?
That's right. There are what used to happen is you'd file your application, then within 5 years you had the option of requesting that the application was examined by an examiner at the Patent Office. Now it's automatically going to go into the queue for examination as soon as you file it, which will be a positive, I suppose, for some people because it means things might start happening more quickly, but there's also a potential for things to get caught up. You know, the examination queues for certain technologies in particular might start getting longer as well.
The level of disclosure and how you describe your invention?
This is the other main change to the actual law. that's come about. So previously, you simply had to, in your first patent application, describe, generally speaking, what the invention was and provide an example of how you might put it into practice. And as long as you provided at least one example, then your claims were effectively enabled for all of the different variations that might occur in that invention. But now, in your very first application, you're going to have enough information about each different way you might put that invention into effect, and just fully describe each one of those. And that's got to be the way it is from the word go. Whereas previously you were allowed to start off with one example and then try and flesh that out perhaps later on.
Is it more onerous on inventors now to get patents through?
It is. You've got a higher standard to meet, and you've got to have a lot more information in your application than what you've previously had to have. And so you are going to have to be better organised, and you are going to have to work quite a bit harder to get your application through and get a granted patent.
I thought I was finished, but it does have applications for our relevance as a patent provider to the rest of the world, because this draws us into line with international standards in a lot of...
That's right. I mean, that's really what's driven this change, is that the government's decided that it's to our advantage in Australia to be more closely aligned with the standards that are applied, particularly in our major trading partners such as Japan, the US, and a lot of European countries. They already apply these higher standards, and so it's to our benefit that we actually start to meet those as well. In the case of our clients, we've probably for quite a few years now, because we're dealing with a lot of Australian-based clients but who are interested in international markets, for them it's always been more important to actually meet these higher standards in the first place, because they want to get patents in the US and Europe and so forth. So even up till now, we've always tried to actually draft their patent applications to that higher standard anyway. But what it means now is those people who have previously been able to get away with something that was at a lower level or not quite as well thought out for the Australian market are going to be dragged upwards to that higher international standard.
If people have got issues, obviously they should be calling Franke Hyland.
Definitely, yes.
And
there's you've really got to have a good talk to your patent attorney about managing your application process and what's the best way to deal with these changes, because there are things you probably should be doing sooner rather than later. And another thing that's really going to become quite crucial is during the development of your technology, timing of that first application is going to become a little bit more difficult, or a bit more of it's going to need a little bit more thought put into it, because previously, as I said, if you were at the stage where you might have had one example, that'd be good enough to file your first application. But now you're actually going to have to leave your application a little bit longer so that you've got all of your technology fleshed out a little bit better than what you previously had to. So managing that process of not filing too early but also not filing too late is going to become a real challenge.